Hello, my name is Eric Willison, and today we're going to be discussing evidence. Evidence. This is going to be the introduction to evidence. It's going to give you the big picture of what evidence is all about. It's not going to give you any specific rules yet. We'll get there. Evidence. What is evidence? Have you ever heard lawyers in a courtroom, or maybe you've seen them in a movie, get up and say, "Objection, Your Honor"? What are they doing? What's that all about? Well, what that's about is that in every trial, you've got a fact finder, somebody who's determining whether in the car accident the light was red or green, whether in the murder case Mr. Jones pulled the trigger, or was it Mrs. Smith who committed suicide instead. They're the fact finders. They're determining what happened in the case. And the only way that fact finder is going to be able to determine what happened in the case is by considering the evidence that is brought before that fact finder. Now, there are two types of fact finders in any case. You've got a judge. If you have selected that you don't want a jury trial, you want what's called a bench trial, you've got a judge. And the judge can then perform two functions. Number one, the judge is going to make the determination whether that evidence is allowable for him or her to consider. Is it within the rules of evidence? And then when it comes time, that judge will then only consider, so the theory goes, the evidence that is proper. Now, you also have the option for what's called a jury trial. And with the jury trial, you select 8 to 12 or however many people the rules in your area allow for to be on your jury and to make the determinations of what happened. Now, the jury, of course, does not get to determine whether a piece of evidence is proper for them to consider or not. That's the rules of evidence. That's going to be determined by the judge. So in that case of a jury trial, the judge will act as a gatekeeper to keep the impermissible evidence, the evidence that does not satisfy the rules of evidence, out, and the permissible evidence as being able to come in. So what you're going to be looking at here is there's going to be three main types of evidence. You're going to have physical evidence, you have documentary evidence, and you're going to have testimonial evidence. For physical evidence might be the gun in a murder trial. Maybe the gun is big and heavy, and the accused is 97 years old and is in a wheelchair and can't really lift something big and heavy. The jury's going to want to feel how heavy that gun is to see, gee, could that person have lifted that gun all the way up there and pulled the trigger? That's evidence. The gun is evidence. The boat is evidence. The broken glass on the floor is evidence. Are these shards of glass so powdered that they couldn't ever cut the man's foot? Or are they big pieces that could have? All of that is physical evidence. Now, there's a second type of evidence called documentary evidence. That could be a report written by an expert witness. That could be a ticket that was issued by a police officer. That could be a witness statement. That could be a video, a picture from a security camera. These would be documentary evidence, examples of documentary evidence. Lastly, you would have testimonial evidence. And that's where a live person comes in and is sworn in and testifies to what he or she could feel, see, smell, hear, or taste. Okay, they got to use their own senses. All right, that's testimonial evidence. I saw the purple car go through the red light. That's testimonial evidence. It's not a video, it's not a report, it's not the car itself. Anyway, so those are your three types of evidence. Now, whether evidence is proper, as an attorney, you want as much of your evidence that's going to favor your case you want as much of that to come in as possible. And the other side, they're going to have some really bad evidence for your case. And you want to try to find out, how do I exclude as much of that evidence as possible? And so you're trying to look at the rules of evidence to see, I don't think he can get that report in because that's got this wrong with it or that wrong with it, and that violates this rule of evidence. And they're going to try to bring in evidence that my client did that before, and that might be a violation of a certain rule of evidence. And we'll get into all those specifics later, but I'm just trying to give you the broad skeleton of the body of law that is called evidence here. Now, so when an attorney is objecting, basically he's telling the judge, I think that this piece of evidence does not fit in under the rules. It's improper, Your Honor, for you to consider, if it's a bench trial, or it's improper for the jury to consider, if it's a jury trial, and you shouldn't let it in. Now, often when there's a jury trial and an attorney wants to make an objection to a piece of evidence, he'll get up before the evidence is shown to the jury and he'll say, Your Honor, objection, can we approach? And then everybody comes on up to the judge's sidebar there, and they talk in low tones. And sometimes they'll even turn on music in the background so the jury can't hear, or static, so that the jury can't hear what is being said. Now, the court reporter will be there, but they'll all sort of huddled in. They'll say, Your Honor, I think that violates this rule. I think that violates. No, it doesn't. And then finally, the judge will say, okay, thank you. Go back to your tables. So he goes back and says, you know what? I'm going to sustain the objection. We'll not be getting into all that, and let's move on. Or if it's going to be a really long and involved argument that can't just be settled by that sidebar technique that I just illustrated for you, the judge may turn to the jury and say, ladies and gentlemen, we're going to have a little discussion over a point of law that you're going to find very, very boring and you won't want to be here for it. So we're going to let you go on back up to the jury room and hang out up there. Maybe now will be a good time for lunch, in fact, or maybe now we'll take our afternoon break and the lawyers will get everything sorted out. And then, after the jury goes away, they're going to say, now, why don't you think this confession of the accused murderer can come in, counsel? Well, Your Honor, I think it was done in violation of his Miranda rights or whatever. And the prosecutor say, he knew his Miranda rights, Your Honor. See, now, if you have that argument in front of the jury, what do you think you're fooling? You just let the evidence in. They know it's in. They heard it, but you send the jury out of the room so they can't hear all that stuff. And now you can speak freely and argue freely from both sides. And the judge can make a decision as to what evidence comes in and what doesn't. Now, evidence is one of the few areas of law that apply pretty much equally. There's a few little distinctions here and there when it comes to between criminal and civil cases. But most of the evidence rules, I'd say about 98% of the evidence rules are the same for both civil cases where there's just money at stake and criminal cases where there could be a death penalty or there could be somebody going to jail for 2 months or 2 years or 20 years or whatever. So evidence applies to almost any trial. Now, there's also something called a hearing, and a hearing might be to determine the nature of something or to determine whether something is going to be let in or not. And oftentimes the rules of evidence will be suspended for hearings. Sometimes not, but it's often important as an advocate to know going into a hearing, hey, Your Honor, before we get started here, do the rules of evidence apply or are we just going to freewheel this one? And then the judge has to make it a decision. And if the rules of evidence don't apply, that could be a big disadvantage to you in your case. Or it could be a wonderful advantage to you in your case. Or it could be both. But you got to know. You got to know what's going on as far as whether the rules of evidence apply. But regardless of whether they apply or not, if you don't know the rules of evidence, then you don't know whether it's good or bad that the rules apply. You don't know whether it's good or bad something comes in, or how to keep something bad out. Because in the end, we have what's called an adversarial system in our system of justice. That means the attorney for the defense argues as hard as he can or she can, and then the attorney for the plaintiff, if it's a civil case, argues as hard as he or she can, and then the judge or the jury has to make the decision as best they can. There's one exception to that rule, which is that if you've got a criminal case, the defense attorney is free to argue as hard as he can or she can and to try to keep as much of the prosecutor's evidence out as possible. The prosecutor, however, represents the state of Ohio or the state of New York or the people of California or whatever. That includes a defendant. So a prosecutor's job is not necessarily to win his or her case. The prosecutor's job is to do justice. So if the prosecutor finds evidence that totally wrecks his case and shows that Frank could not have possibly murdered Joe because Frank was in Puerto Rico, if this were a civil case, maybe you don't want that evidence in. You try to figure out some way to keep it out, evidence-wise. But if you're a prosecutor, you can't be doing that stuff. You got to turn it over to the other side, and you have to make a decision. Is this the truth? I could win this case using this rule of evidence to boot this piece of evidence out, and I could convict Frank, but Frank didn't kill him. So what do you do, Mr. Prosecutor? Well, if you're ethical, you boot the evidence, and you say, Frank gets a pass. He may be a lousy guy. He may deserve to go to jail for 100 other reasons. And you know what? You might be able to convict him on 99 of those other reasons. But if you try to use the rules of evidence to get an innocent man into jail, even if he's only innocent on one thing, I think you got a problem, and I don't think you should be able to look at yourself in the mirror. And we got too many prosecutors these days that shouldn't be able to look at themselves in the mirror. But whatever, that's me just going off and talking about some non-legal subjects. Anyway, that's the overview of what evidence is all about. That's the introduction to it. That's what you sort of have to know about this whole thing before we get started into the specific evidentiary rules.